Distinguished guests, learned speakers, respected members of the bench and the bar, eminent academicians, and dear colleagues. I, Preeti Sharma, on behalf of the entire DAW 2025 committee, welcome you to today's deliberation on Drafting of Enforceable Awards, International Best Practices. Let me start with the truth. Across ages and cultures, two things have always mattered the most: time and money. And nowhere is that truer than in arbitration. Parties invest months, sometimes years, and enormous resources in presenting their case. But if the final award is poorly drafted, unclear, inconsistent, or incomplete, all efforts are in vain. Enforcement challenges mean more hearings, more appeals, and more delays. In other words, we lose time we can never get back, and money that no one can afford to waste. Then what's the point of winning if you can't enforce the award? That's the make or break question. And that's why drafting an enforceable award is not just the end of the arbitration, it is its defining moment and preserves the entire purpose of ADR, timely, effective justice. In the words of Ayn Rand, throughout the centuries, there were men who took first steps down new roads armed with nothing but their own vision. Today, we are privileged to have with us some such visionaries as our speakers. It's my privilege to welcome Honorable Mr. Justice Shekhar B. Saraf, Judge of the Honorable High Court of Allahabad. Justice Saraf's illustrious career spans private practice, government representations, and international exposure, including Chiweening Scholarship for the Young Indian Lawyers Program 2000, sponsored by the United Kingdom. He qualified as a solicitor of the Supreme Court of England and Wales and served as senior standing counsel for the Government of India. Honorable Mr. Justice Saraf has distinguished himself with his insightful judgments and deep engagement with commercial and arbitration law. His contributions reflect both intellectual rigor and a commitment to strengthening India's legal framework in a rapidly globalizing world. Every world has its trailblazers, the people who not only master the practice but also shape its future. In international arbitration, Dr. Jane Willems is one of the names that we are fortunate to have with us today. As one of the most respected voices in international arbitration, Dr. Jane has served as president of the tribunal, co-arbitrator, sole arbitrator or counsel in more than 50 international arbitrations, including international commercial arbitration before international arbitration institutions. Beyond practice, Dr. Jane shapes the field as Associate Director of the International Arbitration and Dispute Settlement LLM program at Tsinghua University of School of Law, Beijing, and is a visiting professor at the Geneva LLM in International Dispute Settlement, MIDS. We are elated to have the presence of Mr. Gourab Banerji, Senior Advocate, former Additional Solicitor General of India. He has particular expertise in arbitrations, both domestic and international. In his capacity as an Additional Solicitor General of India, from 2009 to 2014, Mr. Banerji represented the Government of India in a number of important cases. For instance, in the case of the Republic of Italy versus Union of India, the famous Italian marine case. Mr. Banerji has appeared as an advocate in a large number of domestic and international commercial arbitrations, seated in India and abroad. He specializes in high-stake and high-value commercial litigation before the courts. He has been a party to various reports which have led to reform in India's arbitration law. Next, we have with us Mr. Siraj Omar SC, Founding Director, Siraj Omar LLC. Mr. Siraj was appointed as a senior counsel of the Supreme Court of Singapore by the Chief Justice of Singapore in January 2019. He specializes in complex, high-value commercial disputes and has more than 25 years of active trial and appellate practice in Singapore courts. He has an active international arbitration practice, appearing as counsel as well as an arbitrator. Mr. Omar also serves on the board of directors of the Singapore International Arbitration Center and as a member of its board's executive committee. He is a fellow of both the Chartered Institute of Arbitration, the Singapore Institute of Arbitrators, and the Singapore Academy of Law. Mr. Omar is also a member of the Specialist Mediator Panel of the Singapore International Mediation Center. Most importantly, it is our honor to have as chair for this session Honorable Mr. Justice Ujjal Bhuyan, Judge of the Honorable Supreme Court of India. Honorable Mr. Justice Bhuyan has had a distinguished judicial career, serving on the benches of the several high courts like Guwahati, Bombay, and Telangana before his elevation to the Supreme Court of India. Known for his clarity of thought and impactful judgments, he brings with him a wealth of experience and a deep understanding of both constitutional and commercial law. With this, I invite Honorable Mr. Justice Bhuyan to help us dive into the art and science of writing awards that just don't look good on paper, but stand firm in the courts and jurisdictions around the world. Ladies and gentlemen, let us welcome them with a huge round of applause.
Eminent members of the panel and distinguished guests present here today. A very good morning to all of you. We had just worked out the way we should proceed with the session. We thought that there will be an introductory remark from the chair, then opening round from the members of the panel, and then we'll have an open house. We'll have question answer session, and based thereon, we'll have a panel discussion as well. So I'll just give a brief introductory remark to the topic of this session, which is drafting of enforceable awards, international best practices. Friends, rapid globalization and increased international trade are having its inevitable consequences. Commercial and trade disputes cutting across national boundaries are on the rise. For settlement of such disputes, time is of the essence. Therefore, the disputing parties would like to avail alternative dispute resolution methods, of which arbitration is the most preferred, rather than going to conventional courts. Halsbury defines arbitration as the reference of dispute or difference between not less than two parties for determination after hearing both the sides in a judicious manner to a person or a group of persons other than a court of competent jurisdiction. Therefore, the first and the foremost requirement is that the parties must intend to submit to arbitration. In other words, there must be animus arbitrandi. Decision of the arbitrator or the arbitral tribunal is final, as there is no provision for appeal. The decision of the arbitrator or the arbitral tribunal, as we know, is called an award, which lies at the heart of every arbitral process. An award is more than a technical decision. It is the story of the parties, their dispute and resolution of the dispute by the arbitral tribunal. Essential purpose of an award is to resolve in a final and binding manner all issues submitted to arbitration. The award is both. It is the intellectual decision of the dispute as well as the formal written record of that decision. Because an award carries significant legal consequences, it must do more than simply declare a winner. The award must specify the remedies in enforceable terms, such as monetary amounts, timelines, or obligations. But more than anything else, we must all remember that the arbitral tribunal has a duty to make every effort to draft an award that will withstand judicial scrutiny, even though limited, and of course, enforcement proceedings. This brings us to enforceability. A question naturally arises as to why enforceability matters so much. The answer is simple. The utility of an adjudicatory process rests not only on fairness and speed, but also as to whether the decision can be recognized and enforced by national courts. An enforceable arbitral award has the same legal effect as the decree of the court. For an award to attain this critical status of enforceability, it must satisfy specific legal prerequisites. The determination must conclusively resolve the dispute. This is number one. Secondly, it must comply with the substantive law relevant to the claim or counterclaim, and should be pronounced following an arbitral process which treats both the contesting parties equally and satisfies the essential criteria of procedural fairness and due process. Should the award debtor fail to comply with the terms of the award holder can seek execution through the court. Therefore, legitimacy of an enforceable award lies in its executability through the judicial system. Article 31(2) of the Ancestral Model Law requires an award to be a reasoned one, an award that not only gives the decision, but also provides the reasoning leading to the decision. Form of the award is governed by both the model law and the national arbitration laws. Though no single template exists, experienced arbitrators adapt their style to the requirements of the jurisdiction where the dispute is being arbitrated. Style and language are vital, so also clarity and coherence. In international arbitration, the audience is often not native English speakers. Therefore, an arbitrator should use simple language which is easy to comprehend and avoid literary jargon. He should steer clear of culturally specific references which may be suggestive of bias. In the Indian context, the form and content of an award is provided in Section 31 of the Arbitration and Conciliation Act 1996. Although arbitration offers a private alternative to litigation, nonetheless, it remains a judicial process, more so when it is put to challenge in judicial proceedings, such as Section 34 or Section 37. Therefore, it must respect the due process at all times. Arbitral tribunals must apply the relevant substantive law and must provide sufficient legal reasoning, demonstrating how facts and law combine to justify the decision. A well-structured award reads like a story with a beginning, a middle, and the end. The beginning introduces the nature of the dispute, the parties and their relationship, the arbitration agreement, procedural history, issues for determination, and the applicable law. The middle is the analytical core. Here, the arbitral tribunal examines each issue, reviews the submission of the parties, evaluates the evidence, and applies the law. This portion often involves resolving contested facts on the basis of evidence and interpretation of the contract. Finally, the award concludes with the dispositive section which contains the binding order that resolves the dispute. The dispositive section is the most practical part of the award, translating legal analysis into enforceable directions. An arbitral tribunal may grant damages, specific performance, restitution, injunction, declaration, or interest. It may also award costs. But what is of crucial importance is that the dispositive portion should be clear and unconditional. For example, the award should clearly state that party A shall pay party B rupees 10 lakhs with interest at the rate of 10% or 12%, whatever it be, from 1st of January of that particular year till repayment. Conditional language such as unless or on condition that undermines finality and therefore should be avoided. Thus, for drafting an enforceable award, the relevant statutory framework has to be followed so that it will not only resolve the dispute, but also withstand judicial scrutiny and enforcement proceedings. Prior to 1996, arbitration in India was governed by the Arbitration Act 1940. This act was premised largely on the mistrust of the arbitral process, if I may say so, by providing multiple opportunities to the parties to approach the court for intervention. Coupled with a sluggish judicial system, this led to delays and manifold complexities, rendering arbitrations inefficient and unattractive. Then, of course, the ancestral model law on international commercial arbitration came in 1985. It was adopted by various countries, and 11 years thereafter in India, we enacted the 1996 Act. Objective of this Act, as we all know, is to minimize the supervisory role of the courts in the arbitral process and to ensure that an arbitral award is enforced in the same manner as if it were a decree of the court. This Act is a composite piece of legislation providing for domestic arbitration in Part 1, international commercial arbitration, enforcement of foreign awards, and conciliation. The principle that courts shall not interfere in arbitral proceedings is a fundamental theme underlying the 1996 Act. The objective of which is to limit judicial participation in the arbitration process, thereby increasing party autonomy in choosing arbitration as a dispute resolution mechanism. The judicial intervention is recognized only in specific circumstances, as we all know, under sections 8 and 9 at the beginning of the arbitral process, then at the intermediate stage 11 and 12, then post-arbitral, post-award, we have 34, 36, and 37. These provisions limit judicial intervention, confining it to matters of procedure, while discouraging review of an award on merit. Therefore, the Indian Parliament's keenness to keep the courts out of the arbitral process is evident at every stage of the legislation. Indian courts must recognize this. But evidence shows otherwise. Two of the premier high courts of the country, Delhi High Court and Bombay High Court, a study was made of commercial litigation before both these courts. And the study has thrown up very interesting insights. In both the high courts, it was found that most arbitral awards are put to challenge under Section 34. Further, there is significant flow of cases from the initial challenge under Section 34 to the subsequent stage of appeal under Section 37. While in Delhi, nearly 70% of the cases proceed to the appellate stage. In Bombay, the figure rises to nearly 90%. the statistics clearly reveal that most arbitral awards are subject to judicial scrutiny at both the stages of sections 34 and 37. The study also indicates that section 34 challenge typically adds 3.6 years to the process, while it extends to 5.8 years when challenge under section 37 is made. Thereafter, there is execution proceedings. In between, there will be 227, then 136, sometimes even curative jurisdiction also. It is also seen that Delhi High Court generally exercises restraint, upholding the award in 80% of the cases. In contrast, Bombay High Court is more likely to intervene, upholding awards in only 53% of the cases. These are matters of serious concern, needs to be debated. Friends, India is a signatory to the New York Convention, main objective of which is enforcement of foreign awards. It serves as a preeminent international instrument governing enforcement of foreign awards. This multilateral treaty mandates that courts in the contracting states should recognize and enforce arbitral awards passed in other contracting states. 192 signatory states have affirmed this convention, and this convention stands as a remarkably successful and widely accepted legal framework facilitating global commerce and investment. A pivotal feature of the New York Convention is its provision of a limited and exhaustive list of grounds on which recognition and enforcement of an award may be refused. These grounds are procedural in nature, intended to safeguard fairness and due process, and do not allow re-examination of the decision on merit. This deliberate leaning or slant, if you may use the word, in favor of enforcement, often described as a pro-enforcement bias, together with the New York Convention's wide acceptance, explains why it is regarded as the foundational and highly effective instrument in international arbitration. Contrary to popular perception, empirical research shows that national courts across jurisdictions overwhelmingly support international arbitration. Foreign awards are enforced in 73% of the cases, thus indicating no significant regional variation in court attitudes. There is also little evidence of any home advantage based on nationality of the parties. Overall, the research supports the view that courts around the world are generally supportive of international arbitration. Sitting on the bench of the Supreme Court, I may also say that there appears to be a subtle turnaround in the approach of the Indian courts to proceedings under 34 and 37. This is clearly visible. So therefore, insofar as courts are concerned, restraint is the key word here, and we should allow arbitration and arbitral process to come to its logical conclusion with the bare minimum of, if not totally, judicial intervention. Thank you very much. And with this, I call upon our panelists to one by one to make a brief submission on the various aspects of enforceability of arbitral awards. So we go away with Gourab, you will start? Yes, first speaker will be Mr. Gourab Banerji. Thank
you. Good morning, ladies and gentlemen. We've come here on the Sunday morning for the last session. Justice Bhuyan has set the stage. I want to start by thanking the Delhi High Court and the DIAC for asking me to speak here and on this topic. And there's a reason I'm mentioning the Delhi High Court and the DIAC. The topic is drafting of enforceable awards, international best practices. And the Delhi High Court and the DIAC have taken the lead in appointing members of the bar, younger members of the bar, who are now tasked with the job of delivering enforceable awards. I think this is a great initiative by the Delhi High Court. Many other high courts have taken it up. And I think appointing members from the bar is a very positive step. And I will talk today about the nuts and bolts of drafting an enforceable award. And I can see a lot of younger members of the bar here. So I'll keep it brief. I've got about, I think I have 5 to 7 minutes. So the first point. So I will only be talking about India-seated domestic and international commercial arbitration awards. The test, either way, you have to draft an enforceable award. Even the Chartered Institute of Arbitrators, in its first article on guidance as to how to write an award, says that you must endeavor to make sure that your award is enforceable. And that's the whole point of the exercise. There's no point in delivering some great academic lecture. So the first point. Point number 1, consider your audience. Who is your audience? Who will read your award at the end of the day? First thing when an award comes as a counsel is you first read the operative portion. Who has won and who has lost? So you start at the tail. That's effectively the first portion everybody reads. Then, of course, there are the reasons. Lawyers will look at the reasons. GCs will look at the reasons. So the second category would be, first would be the operative part. Then the lawyers will come in, look at the reasons, whether you challenge, whether you accept. The judges will look at it. In our situation, the judges almost inevitably look at it because we inevitably challenge the award. So the judges will look at it, either 34, 37 or wherever. Institutions will look at it. This is very interesting. DIAC has a particular rule, I think it's Rule 31, and I was asked once to do this by Justice Bakru. You are sent a draft award. You have to look at it and see whether it meets a certain guidelines. Obviously, you cannot interfere. I will tell you something about what I did when I come to that stage. But institutions will look at your award and make some helpful and maybe some not so helpful comments. People who've dealt with the ICC and SIAC know how these things happen. And last but not least, in many jurisdictions, other people will also look at your awards. Some cases, awards are published. Some cases, there are reputational issues if your awards are set aside. But that's a broader point. I'm not going into it. So this is who looks at your award. So what is the general structure of the award? Of course, there are various ways you can do it. But practically today, virtually across the world, there is almost a set pattern in which you write an award. And there are good reasons for it. So you will have a cover page with some details about the institution or ad hoc or who are the parties, what is the type of award, etc. Then you come to so I'll quickly run through the 7 or 8 headings and the pitfalls so that when you write the award, please keep this in mind. Introduction with having the parties, the representatives, the arbitrators. There should be in that portion some aspect of declaration of independence of the arbitrator mentioned, because that is now a major factor. Somewhere it should come. The second portion usually has the arbitration agreement. It has the contract, the agreement. There may be other aspects like seat, rule, language. But here the pitfall is sometimes there is a jurisdictional challenge. Normally, you can get away with not mentioning the arbitration clause in any detail, but ideally, you should set it out. Then we come to the third portion. This is where, when reviewing awards, one finds a pitfall. The procedural history in an award is much more important than in a judgment. In a judgment, in a court of law, you know how the matter is proceeded. Procedural history is very, very important. There are orders that you pass, there are challenges that are made. You have to demonstrate natural justice, you have to demonstrate you give the parties a choice. And particular problems arise when it's ex parte. You have to ensure that the other side has been informed by the various recognized ways. Otherwise, ex parte awards, which are quite common, can run into severe enforcement problems. You should also mention 29A, what is the period, extension, etc. But this is something which I find in many awards is neglected. Procedural history is brushed aside. Unfortunately, there is this procedural paranoia, so it is better to set it out in some great detail. Then you come to the factual background. I mean, that is pretty obvious as to what is to be done. Factual background, and then a question of how the matter came to arbitration. There are some clauses where you have a mandatory procedure of conciliation, etc. So please don't miss that out. Make sure that that has been addressed in your award. Basically, you have to essentially tell. So the next portion. So you can juggle this around. You can put some portions before, but all this has to be covered. Then we come to another area which is always problematic: summarizing the parties' contentions. Major area where there are problems. Very often it happens that X, Y, Z has been argued before you, and suddenly in the written submission, some new point has been slipped in. We lawyers are very good at this. Or you have a situation where you have a mismatch between what has been argued and what are your reasons. Many international awards sometimes, and we know this is true, are written, the factual portion and the arguments are written by tribunal secretaries. So you find in many awards, there's a problem. XYZ has been argued, ABC has been found. You've got to be sure that you've dealt with each and every argument. Many awards have been set aside. I think possibly Siraj may mention some in the international context. You can't decide what is not pleaded. You have to deal with every argument that has been pleaded. You can't suddenly, if you want to go into arguments in the concluding submissions which were not there before, you have to give parties a chance. So that's another area of enforceability which you will have to consider. Last three portions, as usual, lawyers run out of time. Last three portions are very important. One is analyzing the issues. Now, there is something called a Goldman formula, which we see in, of course, we give it a fancy name internationally, but very often arbitrators take the easy route and say, well, I will decide all the points that arise from the pleadings and leave it at that. That's the classic Goldman formula. Very bad idea. You have to apply your mind. You have to frame issues. You have to frame points of dispute. Please don't adopt this so-called Goldman formula. Unless you crystallize the issues, you will run into difficulty with the enforcement of your award. Please don't do a general, which actually, unfortunately, is very, very common. So then, of course, you analyze the issues and you give reasons and you discuss each of them. Let me tell you two instances which I have come across personally where there have been problems with reason, or at least I can go on. There have been awards where you see argument, conclusion. In fact, Delhi High Court has set aside some awards in this fashion. So reasoning is crucial. In the few cases that I was given by the DIAC to review, there was one award, draft award, and I looked at it and I did not know what to do because it was a very distinguished arbitrator. So I wrote in a roundabout fashion that perhaps the learned arbitrator might consider bolstering the reasoning on this and this issue. I don't know how that went down, but anyway, I wrote it and sent it. you have to have some degree of analysis, otherwise your award will be vulnerable. Judges are judges. They will look at your award. They will want to see your reasoning. There was a AAA case. So this is not an Indian problem, by the way. There was a AAA case. I can't see the other side here, so I can mention it. It was settled. It was a AAA case. It was an enforcement of a foreign award under the New York Convention. We brought the award here. We brought it to Delhi High Court. We were enforcing it. Matter got settled. The reasoning of the AAA was pretty poor. It was an ex parte award. So it said, so-and-so has said this, so-and-so had said this, so-and-so has said this. We agree, we award so much. So it is not an Indian problem, but it is an issue that you need to keep in mind whenever you write your award. Then finally, what Justice Bhuyan has mentioned, the dispositive section. This is chaos. I can tell you in every big matter, there is some 33 application, there's some calculation error, there's some lack of clarity. There are awards which are sustained by the Supreme Court. You come back in execution, you have some contradiction between the dispositive section and the something in the main text. Forget the rest of your award. The most important portion is the dispositive section. The most important portion, because that is what it's all about. It's all about money. It's all about calculation of interest. It's all about from which date. It's all about conversion of foreign exchange if such an issue arises. Most important section, dispositive, in which I would include interest. Let me tell you, all our awards, everything turns on interest. We are a litigious society. By the time the award comes up, the principle is something one can settle on, but it is the interest which kills you. So what rate you're giving, from which date you're giving, was there a demand? I have come across cases where there has been no demand. The demand is in 2020. The interest has been given from 2006. So there are so many cases where this interest problem comes. And last but not least, costs. This is something we completely ignore in our domestic jurisdiction. There is a 31A. You should actually award actual costs. You should call for statements of costs, and you should award them. In commercial matters, there should be no hesitation in awarding actual costs. That is our public policy. We don't do it. Please spend a little bit of time on the cost evaluation. In international matters, there are separate costs award. We don't have that situation here. I mean, our claims are much smaller, and the tradition is not to have a separate cost award. And of course, ultimately, there's the signature, there's the seat. Seat, of course, you know how important it is now with BGS, SGS, SOMA. Where do you file the challenge? It's the challenge at the seat or the jurisdictional court. That's another whole debate. But there are lots of materials on record on the net. There is an excellent guideline by the DIAC. I have seen the ICC guidelines. I've seen the Chartered Institute of Arbitrators, but the checklist of the DIAC is world class. So once again, I congratulate the DIAC, and I hope the younger arbitrators and not so young arbitrators will keep some of these points in mind in drafting an enforceable award. Thank you.
So now we'll have a international perspective. Dr. Jane Willems, we would like to have our views on this.
A very good morning to all of you. It is a pleasure to be in Delhi and to address, together with my co-panelists, the issues of drafting enforceable awards. Let me first indicate that I fully agree with all the views that were provided by my co-panelists. I will just want to add a few comments from an international perspective. I have sat in different commercial and investor state arbitration, and I have sat also in arbitration that are seated here in India. So it is a pleasure to address before the audience some of the experience and some of the matters that I have been covering through my brief career. When drafting an arbitral award in international commercial arbitration, there are different elements that the arbitrator and the chair who is writing the award must keep in mind when coming to the moment he or she is drafting the award. There are three essential elements, I think, which will concur in assisting the arbitrator to render an enforceable award. When drafting an award, the first core element is to ensure that the parties had a reasonable opportunity to be heard, meaning an opportunity to present their case. This is one of the core principles of arbitration, and it is enshrined in both statutes and arbitration rules. The arbitrator, therefore, have, as it's been said just before, make sure to reflect in the arbitral award that these requirements are met, both from a procedural perspective, but also from a substantive perspective. Arbitrators do recall at length in the final award the procedural history from the initiation of the arbitration up to the rendering of the final award. It is, for some, it's been said yesterday, it is a tiring exercise, especially if it's conducted post-hearing when the award is drafted. But let me tell you that not every arbitral tribunal share this view. Let me give you an example. In the very famous case rendered before the Stockholm Chamber of Commerce, the awards in the case Renter 4 versus the Russian Federation, the two awards that were rendered, the first one on jurisdiction and the final award, set forth in one paragraph the procedural history. Let me quote from the award. It's very short. The tribunal sees no need to burden this text with a recital of correspondence with counsel, nor is it necessary to set out the content of the procedure orders. They've all been reduced to writing. Suffices to say that at the end of the hearing, the preliminary objection that the parties expressly confirmed that they considered the objections were ripe for adjudication. In the final award, it said, the document assumed familiarity with our award on preliminary objection. In the interest of economy of expression, it will not traverse the procedure and correspondence, which are a matter of record. So why do arbitrators, why do institutions raise the point that there should be a procedural history that is addressed in the award? First of all, it has to do with satisfying the parties and satisfying the institution and the reader of the award and the enforcing court or the courts who will review at the seat the award that due process requirements were met. That at every time of the process, from the constitution of the tribunal up to the rendering of the award, the parties had an opportunity to be heard, that the parties were notified of the step of the arbitration, and that when the parties had to be consulted by the tribunal met those requirements. So it is a matter of trying to avoid, trying to anticipate at a later stage possible challenge on the award, on the enforceability of the award, on matters of due process. Just to call in particular when an award is rendered by default, to raise all the notification and provide for all the notifications made by the tribunal, so that at the enforcement stage, the party against whom the award is rendered does not try to reconsider the record that we just spoke about. The procedural record is set forth by the arbitrators. So this is one of the reasons why we always have a long, lengthy, maybe boring summary of the proceeding. The second element of due process has to do with the substantive matter. The arbitrators will always recall each party's case. They will identify the issues and the disputed facts relevant for the determination of these issues. They will determine what issues are for record or do not need to adjudicate so that they can focus on the disputed matters. And they will summarize the arguments made by the parties in support of their submission on each of these issues. They want to show, by doing this, that the tribunal was aware of the argument and the contentions of the parties, because the tribunal is to address these contentions in the award. Why is it important? Why is it important, that part of due process? Because the sanction is very strong. Article 32 of the model law, second ground of annulment, provides that a party making the application for annulment may request the award to be set aside if it was not given proper notice of the appointment of an arbitrator, if it was not given notice of the arbitration proceedings, and or was otherwise unable to present its case. Unable to present its case goes both to the procedure, the way the case was adjudicated, but also on whether its arguments were heard by the tribunal. Same thing on enforcement of award. The second ground to set aside, to refuse enforcement under the New York Convention is also the fact that a party may not otherwise be able to present its case. So at each step of the procedure, a tribunal will show that it afforded that possibility to the parties. The second element I'd like to raise has to do with the quality of the award. We have heard from the other panelists the content of the award. Let me focus on one element, which is the core element of the award, is that an arbitrator will provide the parties with the reasons supporting the decision. The reason award. It is the award that contains the thought process underlying the decision of the arbitrator. So what does the arbitrator do? What is the process? He or she first determines what the disputed facts are. Then he or she states the relevant legal authority that will be applied. Then he or she explains how the decision was made by applying the law to the facts as the tribunal found the facts were. And then he or she must reach a clear conclusion. The duty is contained in the statutes and the rules unless the parties opt out of the possibility of a reason award. But by default, an international award should contain a reasoning. Now, the question is, what is the extent of the reasoning? Well, in a 1981 case, the English Court of Appeal in Bremer versus Westzucker wrote, establish the facts first. How? Arbitrators should set out what, in their view of the evidence, did or did not happen. Second element, the legal reasoning. The tribunal should explain shortly why, in the light of what happened, they have reached a decision and what the decision is. Therefore, the determination of the dispute, which is final, is, however, potentially being reviewed by courts when reading the award. Not the determination on the merits, which is final, will be reviewed, but it is the path chosen by the arbitrator to reach that decision that is subject to review. Now, let me tell you, we just heard about an American Arbitration Association award that was sanctioned in Delhi. Let me tell you about a recent case in Hong Kong. In the case A versus B rendered in 2024, it was concerned the enforcement of an award rendered by a sole arbitrator under the same rules of the American Arbitration Association. An objection was raised to the enforcement of the award, and here is what the judge of the Court of First Instance said. However generously the award in this case is read, I have to agree with the respondent that objectively read, and in the context of the issues raised and the submissions and the arguments made before the tribunal, the arbitrator failed to adequately explain in the award the reasons for her conclusions made on the key issue in the arbitration. 1, the applicable law. 2, the effective date of the agreement, of the termination of the agreement, and 3, on the enforceability and the reasonableness of the enforcement of a non-compete covenant, which were all issues before the arbitrator disputed by the parties. Let me give you an example. On the governing law, what the arbitrator did is that the judge said we cannot find any analysis on how the arbitrator, in the context of the submissions that were made, came to the conclusion that the governing law was Maryland law. The key is that when a party reads an award, it should understand why a central issue as the governing law in an arbitration was decided. And in this case, the party could not understand. The parties reading an award should understand how the arbitrator reached the decision. Therefore, what did the arbitrator do? It set the provision in the contract. It made no analysis on an explanation how it reached its conclusion. So what was the decision here? What did the court say in Hong Kong? We cannot enforce this award because it is contrary to public policy to enforce an award when important issues which the parties are entitled to expect to be addressed in the award are not addressed. So the quality of the award and the training in writing awards, the training in drawing a legal argumentation is core to the arbitrator's work. Now, let me give you a final element that is of growing importance to parties, is that the parties are entitled to a cost-efficient determination of their dispute. That's one of the core elements of best practice in international arbitration. A prompt delivery of an arbitral award is part of an efficient process. No black hole after the final hearing. The arbitrator should give some deadlines, some time limits, some indications to the party as to when the final decision should be expected, either after the closing of the hearing or after the submission of the post-hearing briefs. As was said yesterday by one of the panelists, writing an award is not a weekend activity. It is a full-time work. Arbitrators must timely proceed with the writing. So some rules, some guidelines provide for deadlines. 90 days for 3 arbitrators under ICC arbitration after the last substantive submission. That means the award should be written well in advance. You don't start when you receive the post-hearing submission. An arbitrator should commence before the hearing, drafting all the non-substantive part that I mentioned in the first element. It should hold the deliberation as soon as possible after the closing of the oral submission. Because, let's make it clear, delay in arbitration will induce cost for the parties and for the arbitrators themselves. The chair should hold the task of writing the final award. It is a well-established principle that when 3 arbitrators sit together, the co-arbitrators expect the arbitrator to provide the draft award and to be in charge of the timeline for rendering the award. And finally, the arbitrator should not delegate the decision-making process to any third party, to any secretary of the tribunal, or be it human or artificial. With this in mind, that concludes my comments.
Thank you, Dr. Jain. We had an overall perspective, international perspective from you. Thank you for your very insightful comments. Earlier, we had comments from Gourab Banerji. So now let us have a Singaporean perspective from Siraj Omar from Singapore.
Very good morning to the Honourable Judges of the Supreme Court of India, the Honourable Judges of the High Court of Delhi and the other High Courts in India, ladies and gentlemen. First, let me thank the Delhi High Court and the organizing committee of the Delhi Arbitration Week for this honor of the opportunity of addressing all of you. As Gourab mentioned, we've been asked to talk about the nuts and bolts of drafting an enforceable arbitration award. And I thought my contribution would probably be most useful if I can talk about my jurisdiction, Singapore. And what I propose to do is look at 3 cases where the Singapore court has set aside an arbitration award and try and glean some instruction for what went wrong. But I suppose before that, the question is, why is it important for us to draft an enforceable arbitration award? If we see arbitration as a journey and the arbitration clause as the start of that journey, then a final, binding, and enforceable arbitration award is the ultimate destination. Parties have entrusted the tribunal with the responsibility of resolving their dispute. They're not interested in the journey, but they want to get safely to the destination. The resolution of that dispute is ultimately manifested in the award. And if that award is not enforceable, then it is a worthless piece of paper, and the arbitrator or the tribunal has fundamentally failed in the very task that he or she was entrusted with. So drafting an enforceable arbitration award is therefore the bare minimum that is expected of an arbitrator. So having said that, let me look at 3 Singapore cases. The first, and these are all 2024, 2025 cases. And before I look at these cases, I should say that the Singapore courts, in its approach to arbitration, does not set aside awards very often. A lot has been said about Singapore being a pro-arbitration jurisdiction, and that means the courts will respect the autonomy of a tribunal, respect the autonomy of an award, and give effect to that award, but it will also look to ensure that the requirements expected of an award have been met. And if those requirements fall short, then the court will not hesitate to set aside either the whole award or part of the award. The first case I want to talk about is a case called Wansen Metal Industries and Hua Tian Engineering. It was a construction dispute between a subcontractor as the claimant and a subcontractor as the respondent. The arbitrator has dismissed the claimant's claims and allowed most of the respondent's counterclaims, and the claimant therefore applied to court to set aside the award. The court set aside the award in respect of one part of the respondent's claim on the following basis. First, that the arbitrator had breached principles of natural justice by failing to apply her mind to the parties' cases in respect of this issue. It was unclear whether she had appreciated the fact that the respondent had not pleaded that issue. The arbitrator had oversimplified and overlooked some parts of the respondent's case on that issue, and the subcontractor had suffered actual prejudice as a result of this breach. So what are the principles that we can take away from that? The first is that we need to be, when we sit as a tribunal or as an arbitrator, we need to be thorough. We need to carefully understand the cases that are put before, the arguments that are put before by both sides, and analyze each aspect of that party's case and make sure that that analysis is reflected in the award. I think Jane mentioned earlier that it's important, and I think Gourab as well mentioned that it's important that the analysis is set out in the award. And if I can venture a very simple approach that one might take, and that is to first identify a list of the issues that are in dispute between the parties, and then take in the award each issue in turn and set out what is the claimant's case on that issue, what is the respondent's case on that issue, what is the tribunal's finding on that issue, and most importantly, how and why did the tribunal arrive at that decision, and therefore the analysis. Because the obligation is not just to deliver an award, it's to deliver a reasoned award. So the reasoning behind the award is critical. So that's the first takeaway. Be thorough, be clear in your analysis, make sure you deal with each of the issues that are presented for resolution by the parties. The second case is DOM and DON, and the reason for the alphabets is the Singapore courts anonymize a lot of these cases to protect confidentiality. So this was another contractual claim involving construction as well. The claimant had brought claims for additional works, extension of time, and for delay. The respondent had counterclaimed for delay and rectification of costs. Both parties succeeded on parts of their claim. So part of the claim was allowed, part of the counterclaim was allowed. The claimant applied to set aside the award relating to consultants' fees that the respondent had been granted. So this totaled about $1 million in fees. The respondent had claimed just under $2 million for 5 consultants. So the respondent had claimed $2 million, it had gotten $1 million. And the tribunal had found insufficient evidence to justify the $2 million claim, but still awarded 50% of the claim fees after applying what it described as a discount for the consultant's fees. And there was no analysis as to how this figure was arrived at. It appeared to be something that the tribunal arrived at as a rough and ready figure. And the claimant argued that in the application before the High Court, claimant argued that this was arbitrary, unforeseeable, and a breach of natural justice. The claimant argued that the parties did not have a chance to address the tribunal's chosen method of valuation of the consultant's fees, and they could not foresee this outcome. The court looked at this issue. It disallowed the fees awarded for 3 of the 5 consultants because for one of those 3, the court found that the tribunal's decision to award 50% of the fees had no clear nexus with the parties' arguments, and for the other 2, the tribunal had no evidence that the services were necessary, but yet awarded 50% of the sum's claims. In other words, there was no basis for the tribunal's findings of the 50%. It was not something that was put to the parties. It was not something that either of the parties had the opportunity of addressing. What is the takeaway? The takeaway is that the tribunal is not a court. Courts have broad statutory and inherent powers to do justice. Tribunals cannot make findings otherwise than based on the arguments made and evidence presented to it by the parties. If the tribunal wants to adopt, to use this example, wants to adopt a method of valuation that was completely different from what either of the parties had submitted, then perhaps the proper way would have been for the tribunal to invite those parties to address that proposed alternative method of valuation, and then form a view, having given the parties the opportunity. So the takeaway is you are confined to what the parties have argued before you and the evidence before you when you make a decision. Third, this was the case of DJO and DJP. I won't go into the facts because they're quite complex and they're not really relevant to what I'm going to say. But long story short, claimant here lost the arbitration. The claimant applied to set aside the award on the grounds that the tribunal had copied substantial parts of the award from awards in parallel arbitrations involving similar facts and similar underlying contracts. The presiding arbitrator had also acted as presiding arbitrator in parallel arbitrations involving the same parties and similar but different underlying contracts. Now, the court set aside the award on the grounds that the tribunal had failed to address its mind to the facts and arguments in the particular arbitration. And the court set out several reasons for this. First, the tribunal had placed weight on submissions made to it in the earlier arbitrations and did not restrict itself to the submissions made in the present arbitration. The tribunal drew upon authorities in earlier arbitrations which were not cited in the current arbitration. Third, the tribunal recited and relied upon provisions of a contract that was different from the one that was the subject of the arbitration. Fourth, the tribunal applied the wrong law to the assessment of interests and costs, and the reason for that was the earlier arbitrations were seated in India. This particular arbitration was seated in Singapore, and so the applicable legal principles were different. So the tribunal applied the wrong legal principles. And fifth, the tribunal failed to consider issues that were unique in the arbitration. And so what is the takeaway? The takeaway is that each arbitration operates within its own set of borders. There may be similar proceedings, you may be involved in those similar proceedings, and this may well be an artificial process, but you do need to place yourself in a bubble when you're looking at a particular arbitration, and you need to consider those facts which are specific to that arbitration, the arguments which are specific to the arbitration, and the legal principles which are specific to that arbitration. If you feel that there are other facts, other legal principles, or other bits of evidence which are relevant, then again, the correct procedure is to invite the parties to address you. It is not for you as arbitrator to unilaterally import things which are outside the arbitration into that bubble in order to make your decision. One last case. There was a dispute, and this related to a dispute relating to sale and purchase agreements for shares in companies that ultimately owned wind farm projects in Thailand. It was an ICC arbitration seated in Singapore, and one of the sellers' claims were for a sum of money referred to as what was referred to as the remaining amounts, which it claimed based on the operation of acceleration clause in the contract. Tribunal accepted the claim, but awarded it to the party on a different basis. In other words, a different basis from what it was claimed. In applying to set aside, the buyers claimed two things: that the claim for the remaining amounts had never been part of the arbitration, and in any case, the tribunal did not have jurisdiction to award the claim or had exceeded its jurisdiction in doing so. The Court of Appeal accepted that this issue had not been part of the arbitration because the buyers had made it clear that they did not consider the tribunal to have jurisdiction. And what the tribunal ought to have done was to have resolved this issue of jurisdiction before making its decision. Again, the takeaway: make sure that you are deciding something that you have jurisdiction to decide. Look at the pleadings, look at the arguments presented, and there's a simple solution which the ICC adopts, which is to have parties agree on a list of issues. And then you make your decision based on that list of issues, because then there's no dispute as to what is or isn't within your jurisdiction. So in conclusion, ultimately, an enforceable award is not about ornate and beautiful writing. It is about disciplined drafting, and it rests on three essentials. First, respect for the jurisdiction that you have. Second, observance of due process. Ensure that both parties have a fair and reasonable opportunity of making their arguments and consider those arguments. Three, clarity in reasoning and in remedies. Credibility of arbitration depends less on winning arguments and more on delivering awards that are capable of surviving scrutiny across borders. And that is why if you have an interest in becoming an arbitrator, then I would encourage you to attend training to familiarize yourself with the process and the rules before you take on your first arbitration. Drafting with enforceability in mind is therefore not just good practice. It is, as tribunal members and as arbitrators, our professional duty. Thank you very much.
Thank you, Siraj, for giving us your analysis based on decided cases. Now, the last of the panelists, we have Justice Shekhar Saraf of the Allahabad High Court. I'll request Justice Saraf to make his presentation. Thank you.
At the very outset, I have to thank the DIAC for calling me in such a distinguished gathering. And I have to state, firstly, that I neither have the gift of the gab of the speakers who have spoken before me, nor the ken of knowledge with regard to carrying on conducting arbitrations and drafting of arbitration awards. My experience is limited to Section 11, that is appointment of arbitrators, Section 34, setting aside of arbitration awards, and Section 36, which is with regard to executing the said awards. So I will speak on those aspects, but before that, if I may point out, Mr. Banerji has very succinctly pointed out the contents of an arbitration award that is required to be enforced. And Dr. Jain has very clearly stated that the soul of an arbitration award is the legal reasoning therein. And these are a must. Without this, no arbitration award can be enforced. I would like to begin now by stating that the arbitration normally offers parties several benefits, including faster and more cost-effective dispute resolution, awards that are cognizant of the commercial and technical background of the dispute, and have greater control over the place and procedure, giving autonomy to the parties. The ultimate strength in the arbitration award lies in its ability to bring quietus to disputes more effectively and efficiently than normal traditional litigation. However, in recent times, we have found that the arbitration process continues to face several shortcomings and is not serving the purpose of being effective time-wise. And one of the most significant of these problems is the enforcement of the arbitration awards. At first glance, issue of non-enforcement may appear to stem merely from judicial attitude towards arbitration. One may feel that there is much judicial intervention, as we judges normally like to interfere whenever given the chance. However, deeper look reveals a more complex challenge. The risk of non-enforcement arises not from judicial skepticism alone, but often from inherent defects in the award itself that unfortunately prevent enforcing courts from executing it as a decree. All the arbitrators, while being adjudicators, are not judges. Since the award emerges from a private process that ultimately requires enforcement by the court, it is justified that courts exercise prudence in reviewing such awards, whether it be at the stage of setting aside of an award or at the stage of enforcing an award. Accordingly, there definitely exists a pressing need for arbitrators globally to strive to adopt the best standards as far as drafting of awards is concerned, to ensure that arbitration as a phenomena operates as an effective alternative dispute resolution mechanism. In 2022, Alfred, Baltic, Hall, and Sasson conducted a detailed analysis of a targeted data set of national court decisions rendered between January 2010 and June 2020 that addressed either the recognition and enforcement of international commercial arbitration awards or actions seeking to vacate such awards. Examining over 1,057 such actions across 74 jurisdictions, the study found that parties generally contested enforcement awards on 19 grounds. I'm not going to go through all the 19. Some of them are incapacity of the parties, invalidity of the arbitration agreement under the applicable law, improper notice of the appointment of the arbiter, arbitral procedure not in accordance with the agreement of the parties, award not yet binding on the parties, award set aside by a competent authority, award contrary to public policy, award lacking finality, enforcement action filed out of time, and several other. The above grounds normally stem from the contents of Article 5 of the New York Convention and also local practices of the enforcing court. The above report discovered that about 73% of international awards under study were actually enforced. I would just like to highlight a few cases which I found to be interesting. Firstly, and surprisingly, failure to mention the correct names of parties may result in vacation of an award. In June 2021, the Singapore High Court in National Oil Well Warco Norway AS, formerly known as Hydrolift AS versus Keppel Fells Limited, refused enforcement of an arbitral award on the ground that it had been rendered in favor of a non-existent entity. Hydrolift, the original contracting party, had ceased to exist following a merger in 2004. Nevertheless, in 2007, arbitration proceedings were started in its name, and in 2019, the tribunal issued an award in favor of Hydrolift. The court, relying upon the judgment in SEB Trig Liv holding AB versus Manches and others, observed that the arbitration itself was a nullity as proceedings commenced against or in favor of a non-existent legal person, and held that such cannot give rise to a valid award unless the naming can be treated as a misnomer, which in the facts was held to be not a misnomer. Now imagine the parties have gone through a process for a period of 12 years. And this exercise in boondoggling, the extravagant expenditure, waste of time, money spent, and then an award is set aside because the name is incorrect. So this is something which needs to be avoided, definitely. Next, of course, is an example of copy-paste that happens. In DJP and others versus DJO, the Singapore Court of Appeal, the Apex Court of Singapore, upheld the High Court's decision to set aside an arbitral award on the ground that the tribunal had breached the rules of natural justice by extensively copying portions of its award from other arbitral awards. When the award was rendered in favor of the appellants, the respondent discovered that at least 212 of the 451 paragraphs of the award were copied from an earlier parallel award. The award also contained errors, including reference to uncited authorities, incorrect application of formulae, and reliance on the wrong law of the seat of arbitration for interest and costs. The court held that wholesale reproduction of passages from the parallel awards created a reasonable apprehension of prejudgment and bias. A fair-minded observer would suspect that the tribunal had failed to approach the dispute with a fresh and open mind, especially since the copied sections were not adjusted to reflect material differences between the arbitrations. The court also emphasized that arbitrators must avoid relying on materials not equally accessible to all parties or co-arbitrators. The last example I would like to give is with regard to application of arithmetic formulae or using best judgment in passing of an award, which may result in setting aside of an award. In June 2023, the Delhi High Court in Satluj Jal Vidyut Nigam Limited versus Jayaprakash Hyundai Consortium was pleased to set aside an arbitral award arising out of the Napta Jhakri hydroelectric project on the ground that the tribunal had entertained financial claims premised on speculative mathematical derivations without any foundation in the pleadings or cogent evidence. So unless a particular formula is in your contract, one cannot use it. If one chooses to use a particular formula, it has to be as per international standards, either accepted by the International Chartered Accountants Association or the industries under which this formula is used. The other speakers have already dealt with other issues that are required to ensure best practices in drafting of enforceable award, and I shall not go into the same in great detail, except in saying that an enforceable award is nothing but a judgment being given by the arbitral tribunal, and accordingly requires ensure proper legal reasoning, being provided therein for the simple reason that the award is for the benefit of not just the parties to the lists, but is required to be coherent and precise so that the same can be enforced by the courts. Mr. Banerji has already provided us with the contents as to the 5 divisions that are required to be made. I would like to highlight just one part of it, which is the dispositive. This is required to be crystal clear with regard to answering all the issues that have been raised in the arbitration. In fact, in my view, a suggestion that maybe one should come up with an executive summary of the issues and then the answers there, and then give the claim that has been allowed and the reasons for the same in maybe a 5 or 6 executive summary that is prepared after the award. Because the court will actually go first, look into that, and thereafter go into the reasoning. A few more suggestions. In case there is a jurisdictional challenge, it is always preferred that the issue of jurisdiction precedes the substantive determination on merits. Secondly, question of liability should be addressed before the assessment of the quantum. And thirdly, any preliminary issue should be resolved prior to related or dependent matters for ensuring enforcement of awards. One must also ensure, of course, that references and precedents cited in the award are correct and the citations are cross-verified. As a last note, I would like to add with regard to artificial intelligence. I was in a session here yesterday where we had a full discussion on artificial intelligence. And it does appear that though artificial intelligence can be used by the arbitrators to making their job easier, but the same should not be a substitute for carrying out analysis. And even if that is done, then that is required to be critically reviewed, independently verified, and where necessary, corrected before inclusion in the final award. Thank you.
Thank you, Justice Saraf, for your very insightful comments from the bench, actually. So, friends, we have come to the round 1 of our this session. So we have, I think we have some time. We have 10 minutes time. We can carve out 10 minutes for ourselves. So the deliberation till now, the thread line is that enforceability of an arbitral award is the key. The process is as important as the conclusion. There must be logical reasoning leading to the conclusion, which must be clear, specific, and unambiguous. Principles of natural justice must be followed. The substantive law, the due process, all have to be followed. Contentions which were not raised during the arbitral proceedings, if the arbitrator wants to work on that, he has to put the parties to notice, hear them, and then take a call. So now I would like members of our audience, if they have any queries, the panelists would be very happy to respond.
Hello, good morning, everyone. My name is Gourab. And a question to the panel, just the last point that you said, sir, that if there are particular arguments that have not been addressed by the parties and the tribunal still wants to invite them and answer on that particular aspect, wouldn't there be possible issues of maybe bias that may be raised by the parties at the 34th stage when such kind of an invitation has been made by the tribunal? I just wanted to respond on that.
All right.
I think there's a thin line there to be drawn. I think you can't completely go off on a frolic of your own, but certainly if in the course of argument, supposing you come across a judgment that neither party has cited, there has to be some nexus, in which event you put it to the parties. You don't decide, you're saying the very fact that you ask a question suggests an outcome. I think arbitrators are sophisticated enough to deal with it and put the point neutrally. But you must put the point to the party. You cannot decide without putting a point to a party.
But should this also be recorded in some manner, or should it just be an informal manner? That is one thing.
You're asking the party, then you send them an email, or presumably you.
I think in the record of proceedings, it should be there, that this point has cropped up. Therefore, I am putting it. It was not argued. Therefore, I am putting it across to the party. Thank you. Thank you. Yes, I can see a hand raised from that corner. Yes. No, we'll come back to you. Let's go there. Yeah.
Good afternoon, sir. Thank you for giving me this opportunity to ask a question. Sir, when there is so much of court intervention in the arbitral process, making the process a lengthy one, and especially up till the stage of the exequatur court, what are the possible solutions that could be practical? Because we have so many solutions, but they don't seem to be so practical and helping.
No, practical lies. The solution is very simple. As I said, it has to be restrained. First thing, the arbitrator should also be careful what he writes or what he decides in the award, and as to whether it meets the requirement of the process of arbitration. And therefore, thereafter, the courts will have to respect the parliamentary, the legislative intent. There should be least judicial interference. Though the statistics, as I pointed out, shows otherwise, but I see a formal understanding of this, realization by the courts that we should not be too interfering in arbitral awards. I think in due course of time, as we are all evolving, as we evolve into this, I'm sure the courts slowly will recede and allow arbitration to have its full effect and force. Thank you. There's somebody from here. Yes.
My question is, have we as arbitrators in the international arbitration started using AI to review the award before it is released? So all the checkpoints are met. So if Dr. Willems or Mr. Omar would.
I don't have any special views on artificial intelligence. I don't use it. I don't think in my career I will ever use it. There are so many cases a human being can take at the same time. The idea is not to go back to back to hearings back to back. It is to deliver a reason award. I always make sure between each main hearing I reserve time. I schedule my hearings 2 to 3 years in advance. And I always have time to write my awards and to not to need the assistance. Now, there are two growing concerns. Now that we are using dematerialized evidence, the number of evidence on the dock is bigger and bigger, and it's very difficult to be able to digest, to read all of the evidence submitted by the parties. Some contracts are 2,000 pages long, but at the end of the day, we only use 50 or 60 sessions of that contract. What's important is the dialogue with the parties and to have them reduce their arguments and the core evidence to what is sensitive to the determination. Now, let me tell you another point on artificial intelligence. Some arbitrators say, oh, I have an award to write this weekend. And some arbitrators say, oh, I have an award written by somebody else to review this weekend. If you are not organized and if you do not have discipline, I don't think AI can assist. No, I see it can assist counsel, but my work as an arbitrator, I don't find the use. I'm often asked, actually, by institution, Jane, how do you write your awards? Do you use artificial intelligence? And there is always a great relief from the institution to know that I don't use it.
Thank you. I think we have our host looking at us very anxiously. So we are running out short of time. So I think we had a very fruitful discussion, very enlightening and enlivening morning, this session. So I thank my co-panelists here and all the distinguished members of the audience for this wonderful session. Thank you.
A truly enlightening session, I must say. I request Honorable Justice Prasad to facilitate the Honorable Chair and the esteemed speakers of the session by presenting them with a Prabhavali. Ladies and gentlemen, may I please have a huge round of applause. While the audience has learned it by now, for the sake of the esteemed people on stage, I reiterate, a Prabhavali is a traditional ornamental arc crafted in intricate brasswork, symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring traditions of artistry and design. We hope it serves as a meaningful reminder of your time at the Delhi Arbitration Weekend 2025 and of the timeless elegance of Indian craftsmanship. With this, we come to the end of the session. I request everyone to join us for the cultural program, which will be commencing shortly. Thank you, everyone.